Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. There is a bit of an interesting filing. It has been submitted as the parties proposed stipulated to jury instruction, and there's a motion that was filed on the 30th of May 2025, although it says motion to seal parties proposed stipulated jury instruction. It's only worded as the State of Idaho coming before the court and not the parties themselves. Usually when something is stipulated to, it will say, comes now the State of Idaho and the defense, or vice versa, the defense and the State of Idaho, and moves the court for the entry of an order, whatever it is that they're looking for. Here, this is a motion to seal. The parties, this means the both of them, not just the state, not just the defense, but the parties, proposed stipulated jury instruction based on the fact that the defendant's filings have been submitted under seal. The state leaves the ultimate determination to the court's discretion, and this is signed William W. Thompson, Jr., prosecuting attorney. If you look back at prior stipulations, it will say that the parties are looking for this relief. There'll be something in here. There might be a signature block for both sides, and both sides will sign it. Or one of the sides will say, I'm filing this on behalf of the parties, but the other side has allowed me to do that. I've spoken with them on the telephone, and they've given me the authority to file this. And then also, the final statement here, the state leaves the ultimate determination to the court's discretion whether or not to seal this proposed stipulated to jury instruction that the parties are bringing forward. And the legal citations, we've seen this many times in this case. This is pursuant to Idaho Court Administrative Rule 32G1 and Idaho Code. This is a statute 74124B. This legal authority has been cited over and over and again. This basically, the rule of court and the statute under certain circumstances allows a court to seal something that would otherwise be subject to public disclosure. Here, proposed stipulated to jury instruction, and the stipulation means there's been an agreement of some kind here. The issue of, based upon the fact that the defendant's filings have been submitted under seal, it's not just the defendant's filings, it is the state's proposed jury instructions as well. Both sides, if you look at the October 9th, 2024 pretrial and trial order, go to page 3, look at the section entitled Trial Materials, section D as in David, you will see a section that addresses jury instructions and a time frame when both sides were to have submitted them. There was no requirement that the jury instructions, unlike other things related to trial materials, such as witness lists, lay witnesses, jury questionnaires, both of which were required to be filed under seal. Jury instructions were never stated in that order needed to be filed under seal. And this has never been brought up in any of the motions that either side have submitted to Judge Stephen J. Hippler to seal proposed, stipulated, or otherwise jury instructions. So just a rather, in my opinion only, when you look at other stipulations, you'll see that this is a little bit different. Also, we now go to the court order of the 2nd of June. This is the order sealing the parties' proposed jury instruction, and it says, based upon the state's motion to seal proposed stipulated jury instruction. So it doesn't even say the parties stipulated to, but the state's motion to seal. Parties proposed stipulated to jury instruction filed. The court does hereby confirm an order that is exempt from disclosure and sealed pursuant to Idaho Court Administrative Rule 32G1 and I for the reasons stated in the motion. So we see here the court is only finding legal authority under the rule and is not citing to the statute for reasons unknown. This is Kathy. Thank you for joining us today.